Human rights and the intersection between environment law. The relationship between human rights and the environment is deeply interconnected. A healthy environment is essential for the fulfillment of fundamental human rights like the right to life, health, food, waters, and adequate living conditions. In turn, the protections of the environment often require safeguarding the rights of individuals and communities affected by the environmental degradations, ensuring their well-being and access to a clean and sustainable environment. This interdependence highlights the integral relationship between human rights and environmental preservation for the well-being of present and future generations. The obvious example of the relationship between these two. The first one is in the Stockholm Declarations, as stated that man has the fundamental rights to freedoms, equalities, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being. And another example could be in the preamble of Paris Agreement, which expands upon this language, calling on states when taking action to address climate change to respect, promote, and consider their respective obligations on human rights. And our focusing for the intersection between human rights and international environment laws would be in the aspect of treaties and the legal frameworks with regard to some example of human rights in connection with environment. The first one is about the right to life. The obvious example could be in Article 2 of the ECHR and Article 6 of the ICCPR, which confer the right to life of everyone falling within the jurisdiction of the contracting state. However, the climate change and associated disaster put the effective enjoyment of the right to life at risk in various ways. For instance, disaster triggered by floods and hurricanes might result in human casualties and increase the death rate. Furthermore, the sea level rise, increasing the climatic hazards, and environmental pollution may threaten the access to the food, clean waters, and other fundamental social and economic rights that are indispensable for the enjoyment of life. Therefore, both Article 2 of the ECHR and Article 6 of the ICCPR confer a positive obligations upon the contracting state to protect the right to life by adopting the legislative, the preventive, and operational measures. Moreover, the treaty itself have confirmed that these positive obligations applies in the context of the environmental degradations where there is a foreseeable risk of the life-threatening harms of which the state was or should have been aware. Therefore, the contracting state to the ECHR and the ICCPR must take an appropriate and reasonable measures to protect the right to life against environmental threats. For instance, states have duties to assess the risks of environmental harm and to inform their populations of future and immediate life-threatening risks.
The next topic is right to a healthy environment. Right to healthy environment was defined in many definitions depending on the legal instrument it was stated in. That in majority of the international texts, it was referred to a right to a healthy environment or a right to live in a healthy environment. That right now, according to the UN Special Rapporteur David Boyd, the right to a healthy environment is included in regional human rights treaties and environmental treaties binding more than 120 states. That the law regarding healthy environment was also constituted in environmental legislation and protected under constitution of more than 100 countries. On October 8 of 2021, the Human Rights Council Resolution 48/13 of the UN Human Rights Council adopted a resolution recognizing that the right to a clean, healthy, and sustainable environment is human rights. By recognizing this right, it must also be noted that it is not an isolated right, but it is related to other rights that are in accordance with the existing international law. The reason for this is that the status of recognition of healthy environment is not a legally binding text, but it supports the further application of requirement for healthy environment to the future law. That as a lawyer, hopefully one day the status of it will be changed to gain more power in benefiting the society. By having such recognition of healthy environment, although it is not yet a legally binding text in the international level, but in some national level it has bring people the procedural rights such as right to receive information, the right to participate, in decision-making about the environment matters and to obtain access to the justice system. The example for this is Philippines, that the country have enacted specific rules regarding environmental litigation to facilitate the protection of the right to a healthy environment. Substantive component is also one thing that the recognition of healthy environment has brought into play. The example for this is the French Environmental Code that recognizes right of all to breathe air which is not harmful to their health, and the South African Constitution that stated that everyone has a right to an environment that is not harmful to their health or well-being.
The example cases where people have brought environmental protection claims to the Human Rights Court. The first case is Lopez Oster versus Spain. The case originated when Mrs. Lopez Oster, a Spain national, filed a complaint with ECHR against Spain. She argued that her family health and well-being were jeopardized due to the hazardous proximity of a waste treatment plant near her residence. The plant emitted noxious fumes and produced unprecious odor, impacting the quality of life of Lopez Oster and her family. Crucially, the ECHR ruled that Spain had failed in its obligation to strike a fair balance between the general interests of the community, including economic development and waste management, and the protection of the individual rights to the healthy environment. The court emphasized that the need for the state to implement effective regulatory framework and preventive measures to minimize the environmental risks. The second case is Ogoniland versus Nigeria. Ogoniland is home to the Ogoni people, an ethnic minority in Nigeria. The region became a focal point of oil extraction, leading to environmental degradation, pollution, and negative impact on the health and livelihoods of the Ogoni people. Oil spill, gas flaring, and the general environmental degradation resulting from oil exploration and production has served consequences for the local population. The case was subsequently brought before the ACHPR, with the complaint argued that Nigeria had violated various provisions of the African Charter on Human and People Rights. They contend that the environmental degradation resulting from oil activity negatively impact their right to a satisfactory environment, as guaranteed under Article 24 of the Charter. Additionally, they claim violation of their right to health, culture, and livelihood. In 2001, the ACHPR rendered a significant decision in favor of Ogoni people. The Commission held that Nigeria had violated Ogoni people's rights under the African Charter and recommended measures to address the environmental damage, compensate affected individuals, and bring those responsible for human rights violations to justice.
We will now focus on the intersection between children's rights and international environmental law. According to a recent report by the UNICEF, millions of children are dying today from diseases related to unsafe water, sanitation, and hygiene.
States have taken it upon themselves to take precautionary measures to prevent and minimize the causes and mitigate the adverse effects of climate change, to protect the life of individuals and children. Additionally, the international community has recognized the special status of children in many international human rights treaties, for example, under Article 24 of the ICCPR. There are two distinct types of obligation arising from the Convention on the Right of the Child, namely negative and positive obligation. A negative obligation means that the state has to respect the rights of individuals and refrain from interfering with those rights. A positive obligation, on the other hand, means that a state has to take positive measures to protect the rights against third parties and to adopt measures that facilitate the enjoyment of these rights.
Which children's rights are affected by environmental problems? First, we have the right to non-discrimination. The impact of environmental harm has a discriminatory effect, and states have an obligation to effectively prevent, protect, and provide remedies. Then we have the right to life and development.
Under the Convention of the Right of the Child, the inherent right to life is laid down under Article 6, and more specifically, the obligation of states to ensure the survival and development of the child, which can be found under Article 6, subparagraph 2. Since Article 6 itself is extremely broad, the Committee on the Right of the Child has, under the General Comment Number 7, provided a guideline for states. The committee has decided that Article 6 can only be achieved if it is interpreted in a holistic manner through the enforcement of all other provisions in the Convention. For example, by providing the highest standard of health, states can also ensure the survival and right to life of the child.
Another right affected by environmental problem is the right to be heard. Children's voices are a powerful global force for environmental protection. Next, we have the freedom of expression, association, and peaceful assembly. These days, children who are engaged in protest on environmental matters often face threats, intimidation, and harassment. States are required to protect their rights. Comes after the right to seek and receive information. It enables children to comprehend the potential effect of environmental harm on children's rights. Then we have the right to freedom from all forms of violence. Environmental degradation is a form of structural violence. Poverty, economic and social inequalities aggravate the risk that children will experience violence, abuse, and exploitation.
The right to health, laid down under Article 24 of the Convention on the Right of the Child, becomes important in the light of climate change, as climate change will affect the right to life of children through issues such as disease and malnutrition. In connection with environmental law, Article 24(2)(c) of the Convention on the Right of the Child becomes interesting, as it is very similar to the UN Development Agenda Goal number 6. Both have as their primary focus the availability of clean drinking water. The Convention on the Right of the Child especially provides positive obligations for the state. For example, the state has to recognize the obligation towards the child when planning and carrying out infrastructure expansion and maintenance of water services to make sure that children have access to clean water. Additionally, states also have an obligation to protect the right of the child against third-person parties, such as commercial actors. This includes that the states take measures to address the risks and dangers that local environmental pollution can pose to the child, and also to make local businesses aware of their impact on the child.
The right to social security and adequate standard of living is also affected by environmental problems. Exposure to environmental harm exacerbates the effect of multidimensional child poverty. Also, we have the right to education. Education is instrumental in protecting children's rights and the environment, but this right is highly vulnerable to the impact of environmental harm, as it can result in school closures. Rights of indigenous children and children belonging to minority groups are also rights affected, for example by the deforestation of their lands. Comes after the right to rest, play, leisure, and recreation, for example climate change related stress on household incomes that may reduce children's time for rest. Finally, in their new guidance, the committee has taken a vital step forward by confirming that children have a right to a clean, healthy, and sustainable environment. The committee also considers that states should take actions as improving air quality or preventing marine pollution, and more importantly, that they should incorporate children's right to a clean, healthy, and sustainable environment into their national legislation. But these are only guidelines and are therefore not binding on states.